one of the most, it's good stuff. This is really good stuff. This is interesting, and this is also probably one of the areas of the most difficult in your practice is dealing with this, because conflict, of course, is conflict between two or more interests. And guess what? One of those interests is you. And guess what? As between you and the client, you know, you're going to have a higher standard to meet. So we're going to talk about that, and it's interesting, good stuff, and important stuff, because it is one of the areas it's the most problematic. So we're going to cover that, all good. Let's get rolling with our joke of the day. And I know there has to be someone that knows a joke, that knows a lawyer joke that you can share that's clean for this class. And if you can't, I've always got one. Like I've always got one. Okay, ready? So, the lawyer is in a car accident. It's always death and dismemberment, something there. The lawyer is in a car accident, lands in the hospital, and is lying in a coma on the bed. And wakes up and looks around the room, figures out where he is, and he notices all the windows across the entire hospital room, all the curtains are closed, blinds are closed, and so forth. And two nurses come in, and he says, and they say, "Are you feeling actually great? You'll be here for a while because of the car accident, so just make yourself comfortable." And he says, "Can you open the curtains?" They say, No, it's not good to open the curtains. And they leave the room, and the two nurses are talking in the hall, and they say, "Well, why can't we open the curtains, for this hospital room?" And the other nurse says, "Well, there's a raging fire burning across the street, and I didn't want the lawyer to think he had died." A little delayed reaction. We're good. Okay. Who are these guys?
Harvey and Mike.
They are Harvey and Mike. Yeah? No, Harvey and Mike, right? Yeah. And what are they doing? First of all, what's the show? I think it just ended, or it's ending soon, or something. Okay, and what do they do? So first of all, so what do they do? We're thinking about ethics, about lawyers, about conduct. What are these two guys doing? Like, what's the theme of these fictional characters? Who watches? Yeah.
Isn't a lawyer in law school?
Pardon?
Mike isn't a lawyer.
Right, okay, so this guy here, right? He either didn't go to law school or he flunked out. Which was it?
Okay, he go to law
He
school.
didn't even go.
Yeah.
Okay, and what's this guy doing?
He hired as a lawyer.
He is a lawyer.
Yeah.
And he's a real slick guy, right? He's the guy that gives us all a bad name. And what are they doing in their relationship? What's going on in their relationship? From an ethical perspective, what's going on? What are they doing? Viewers, what's the storyline? Don't watch it. Yeah.
That's the associate.
Julie.
I think Harvey hires Mike as his associate.
Yeah.
Knowing that he didn't go to law school.
Right. Because he's like,
I'd say that as
because
he's really smart.
he's really smart. Okay, so what, from a look, let's put on our ethics glasses looking at this, and the characters are just fictional. But what do we say about Harvey, who is a lawyer, who hires Mike, who's not a lawyer, and knows that he is acting as an associate, even though he doesn't have the qualifications? What is going on for Phil Spector? Harvey. What's going on with Harvey? What do we think from an ethics perspective? What's Harvey all about, Julie?
He just really cares about winning cases instead of actual ethics.
Right. His profession, his reputation, his success rate, and so forth. What kind of conduct did we talk about? Let's go back a few classes. What kind of conduct did we talk about that might apply to Harvey's conduct? So Harvey is acting in his capacity as a lawyer, sheltering or engaging Mike. So what's Harvey's issue, ethically speaking? What's Harvey's issue? Simon.
Is it that he's overly zealous?
He may be overly zealous. right? Gotta win my cases, I got this smart kid, I'm gonna take him on. What else is he doing conduct-wise in terms of his professional capacity, Manuel?
I think like he does everything to make sure that he satisfies his clients. He wins that case, no matter whatever issue he has to breach. He goes ahead to do it just to satisfy his clients.
Okay, so in terms of the comment about him being zealous and putting his client first at the sacrifice of all others, we looked at that. And let's talk about Harvey in the context of professional misconduct. What's going on with professional misconduct in Harvey? Does he have an issue with the Law Society? I haven't watched the show for a long time, we're over to the end, so I don't know what happens. But if the Law Society were to come knocking at old Harvey's door, what's the professional misconduct possible issue they may be concerned about? Remember we talked about two concepts, professional misconduct on the one hand, and the other one was conduct unbecoming, which is not in the professional world. Remember we talked about go to your son's or daughter's baseball game and you scream and yell and swear at the ref. Like you're not wearing your lawyer hat, but like it's a little dodgy. So what role is Harvey in this scenario? What hat is he wearing? Yeah, he's not the baseball coach, right? He's the lawyer. He's acting in a capacity that might, according to the Law Society, if they knew all of the background to this, right? Professional misconduct? I don't know, maybe. It's a little gray. One.
Well, he's sharing information of the clients of the firm with someone that is not a lawyer. So.
And he has a duty of confidentiality.
That's right.
Remember we talked about that. So he's doing that. So is what's her name in How to Get Away with Murder?
Annalise.
Yes, right? Because she brings the whole class in to interview the clients, all kinds of. That show is great, but it's all wrong. Totally wrong. Right, exactly. So Harvey's got a few issues going on. What about Mike? What would the Law Society, if they were figured out, say about Mike and Mike's conduct? Yeah, Ahmed.
That he's incompetent?
Yes, okay, but he's not qualified yet as a lawyer, so he wouldn't have that obligation. But built into that is another problem too for him, right? I need your name tags, people. I go home, I forget about you. Shami.
Impersonating a lawyer, which is kind of like a fraudulent.
Yeah, exactly. Practicing without a license, right? Which you're not allowed to do. Because we have this whole system built up where we have controlled entry into the profession, rigorous education, testing, and so forth, right? So they both got separate issues if you look at it from an ethics perspective and a possible Law Society case. So this thing, I think, takes place in New York or someplace, but anyway, it's shot in Toronto. Okay, any other thoughts about these guys? Okay, let's start our day. Good morning, and here we go. And here is my disclaimer, because what hat am I wearing today? Can't hear you. Yeah, I'm not acting as a lawyer. I'm not representing any no clients. I have a disclaimer, right? Okay, and today we're talking about conflicts of interest. Really good stuff. Important, and it will, you want to avoid it. You want to avoid this. Let's learn about it. So conflicts of interest. Conflicts. So because we have that imbalance, right, as between you, trained, tested, licensed, meeting all the requirements, versus the client, you have a higher obligation duty, you have all these ethical rules that your poor client walking around the street, they don't have to comply with any of that. They can share confidential information. They can do whatever they want. But conflicts is also about appearances. It's about optics. It's what a situation looks like, not always necessarily what it actually is in terms of conflicts. And why? We know why. Because we have this obligation to maintain the integrity of the profession and maintain respect for the profession of lawyers. And every time you do something, all of us are standing behind you and you're representing us. So don't go and do something goofy and silly that optically reflects poorly on everybody, right? Justice must be done, but it must be seen to be done. Optics. You have to avoid impropriety. You have a duty to act as a zealous partisan. We know there are some limits. There are some, boundaries to that, but generally you do. And the clients have to trust their lawyers. We have confidentiality obligations, which helps build, enhance that trust. So you can't be in a position of conflict where you take advantage or benefit from information received from clients. Makes sense, right? So what can be a conflict? Sure, acting against the client. You've got problems there right off the bat, and that's why you have a lot of databases and screening mechanisms before you take on a client. Lawyers, associates, your whole firm, you have to avoid business conflicts, you have to avoid personal conflicts. Is working on an hourly rate a conflict of interest? Hands up. Is working on an hourly rate a conflict of interest? Hands up. Yes, it is. Hands up. Nope, no problem there. Okay, so why do you think there's no problem? Who put up their hand? Cassie.
Because you're working for the client, you gotta bill him, you gotta make money.
It's not a charity. It's not pro bono in this case. Right? You're making a living. You went to school for a long time. You got debts to pay off, right? Kids to put through law school, right? Okay, so if you bill at an hourly rate and you're doing some research, and you research for 10 hours, and you say, well, I think I know the law here, but if I research just a little bit longer, I'll know a little bit more law. And guess what? I'll bill a few more hours. Is that a conflict? Is that a potential conflict? I don't know. What would the Law Society say? You've already done your work, but you did a little bit extra. Did you need to? Did you have to? Because you billed the extra.
That's big.
Pardon?
That's big.
It's big. I agree. It's great. But you can see the potential, right? You have a case that can go to trial, did I already say this? For 6 weeks and bill lots. Or you can settle and have 1 day appearance for a settlement. Is that a conflict? For you as a lawyer to tell your client which way to go, or to recommend to your client which way to go. Is that a conflict? Hands up, yes, that's a conflict. And no problem, I'll do whichever's the best. So who said yes, it's a conflict? Who said yes? Who said yes? Yeah, why, Ahmed? Why do you think that would be a conflict?
I think because you had two options and you chose the one that can get you more money.
The one that benefits you,
Yeah,
right? So there's your inherent potential conflict. And also we know our model code rules always encourage settlement, right? So you've got sort of 2 layers there going on in terms of conflict for your personal benefit and the rules that specifically say must always encourage, whatever number it is. You've seen it, you know, right? Having an outside business activity, you have to and you can do this. You can have a family business that sells furniture or what have you, no problem. But it has to be clear that you're acting in that capacity and not in your lawyer hat capacity, right? Monies received from outside activities should not go through the trust account at your law firm or your business or whatever. They should not bring the practice of law into disrepute. This is that ongoing notion that we have to uphold the respect for the community and the profession. Also public office, right? Lots of lawyers like politics. Hooray, the election's over. No more analysis. No more talking heads. You can hold public office, no problem, just it has to be clear that they don't conflict with your professional interests. Okay, so the Supreme Court of Canada, in its wisdom, has developed a trilogy of cases. And you've seen this in other courses, right? The Supreme Court of Canada, they develop a concept over a number of years when the correct case comes forward and they can build on it. They can build on their guidance. And because they know what's coming down the pipe, they're listening to a case today, they know in a year and a half another case is coming down the pipe on a similar issue, so they can build on it, right? So this trilogy is about conflicts in the Supreme Court of Canada. And you can see the earliest of the cases sort of go back to 1990, and then 2002, and then 2000. So over a number of years, and they build on this notion and this concept, and provide us with guidance, right? So we look to that, we look for where the court sees the issues. And over the course of you have to read the cases in sequence, you have to build on the concepts, and sometimes they reference back their own older cases. But they set out a set of expectations of lawyers in the face of conflicting demands grounded in fundamental values. And it's kind of broken down, there are no hard lines, right? Current clients, former clients, and business interests. So let's start with the middle of the two cases. So R.V. Neal. So R.V. Neal, right? Criminal law case. And R.V. Neal is a case where a certain law firm has both a criminal and a civil action going on. There's a little bit of a bridge, right? So in R.V. Neal, what happens is there's a criminal charge for defrauding Canada Trust, which is like a bank institution, when he was a paralegal. And so that's on the criminal side. And divorce documents that he created on the civil side, right, for a divorce, for a family law matter, right? And from time to time, Neal, who's a paralegal, would refer matters to a particular law firm, or Calumet, and they had a particular employee. Now, the facts are a little convoluted, but that's not the point. The point is you've got a number of players, you've got two areas of law, criminal and civil, right? So he refers matter to the firm, Lazen's an employee, and he represents one person at the same time that the firm represents Neal. Remember, just because you're the lawyer on the file, or someone else in your law firm's a lawyer on the file, like the whole firm, right, is captured. Even though you may never shake hands with the client, or you may never attend court or whatever, it's still considered a client of the firm. And there's some crossover meetings, and he hears information on the civil side, and he's acting on the criminal side, so you've got overlap of information. What does the court say? Neal wants his so on the criminal side, he wants his conviction set aside. Why? Because of a conflict of interest on the law firm. They've got their hands in two pots. They're the same, firm with two criminal and civil. And the court says, well, there's no abuse of process, not enough to order a retrial on the conviction. But they do comment. They say the law firm should not have taken on, this is a bit too big, the law firm should not have taken on the Canada Trust matter civil matter, they shouldn't have taken on the defrauding, the criminal matter. Should not have taken on the civil matter while representing Neal in a criminal matter. And the law firm was in conflict, and although they weren't going to order a retrial, they said the Law Society can prosecute, right? Can investigate and discipline. So the law firm escapes, problematic issues with Law Society, with the Supreme Court of Canada. But there's always the threat, hanging over us of the Law Society getting involved, which can have, the Supreme Court can set aside a conviction, retrial, that kind of thing, but the Law Society can take your license. So that's a parallel, separate hearing, but very serious consequences there as well. The Supreme Court says there was a breach of the duty of loyalty. And what do? They give us a test. Our favorite thing is tests. So now you have a test. The Supreme Court of Canada says, here's your test. Your test is called the Bright Line Rule. The Supreme Court's full of really smart people. And they call this rule the Bright Line Rule because it's a bright line. When we say things like there's a line in the sand and there's a clear demarcation, they say it's a bright line. And it is the general rule that a lawyer may not represent clients whose interests are directly, so we know language is important. We know the Supreme Court chooses its language. We know they write tests for us, but they're never sort of straightforward, right? They've got these layers to them. A lawyer may not represent one client whose interests are directly adverse to the immediate interests of another client even if the two mandates are unrelated, unless both clients consent after receiving full disclosure, independent legal advice, and the lawyer reasonably believes that he or she is able to represent the client without adversely affecting the other. So it's a test, got like 5 components to it, right? So what does, if you break it down, what does interests who are directly adverse to the immediate interests of another client mean? Like, what does it mean? Who knows what it means? Who knows what it means? It depends on context, it depends on your facts, it depends on your situation. But at least you've got some guidance, you've got some words, you've got some direction that'll tell you. Okay, I gotta stop and think now. I've got 2 clients. Have I got directly adverse to immediate interest? What does immediate mean? Of another client. But then that's not enough. You can't just say, oh, no, they're separate matters, right? Because the test says, even if the mandates are unrelated, even though there's no crossover or relationship between the 2 types of work that you're doing, you might still fall into trouble with this rule. But you can be okay. You can back out of this problem by both clients consenting, so you gotta have full disclosure to both clients of how you're acting in the firm, and they consent with full disclosure, and at the same time, you have to believe that you're able to represent them without adversely affecting them. So it's a test, it's a helpful guidance. It's not that straightforward, but at least you have something, right? At least you have something you can take off all of the elements before you proceed. So what does Binney say? He says a conflict, it can be a business conflict, doesn't have to be a legal conflict, so it's a little bit wider than just acting for the 2 parties. Loyalty includes putting the client's business ahead of the lawyer's business, which is practice law. What are information walls and cones of silence? What's that? They're not enough, by the way. What's an information wall? Used to be called a Chinese wall, called information wall. So you work in a law firm, right? And you work on the 10th floor, and you work on the 20th floor. And all the files you work on, intellectual property, and all the files that you work on, real estate, are separate. So an information wall is a barrier. Your pass key won't enter his floor. You can't access his files. You can't cross-reference his legal memos and so forth. So an information wall is usually electronic or data-based or metadata-based barrier in, the key card thing is physical, obviously, but they're barriers that prevent information sharing as between 2 individuals in the law firm. But, which, good thing, right? Normally you'd think you can't access, so you've got some protection there. But Binney says, not enough. They don't apply in the context of breach of loyalty because they talk about confidentiality and separate but not loyalty. And ultimately, you have to decline. If you think the conflict is sufficiently potentially serious, you may have to decline and turn away the business. No one likes that. No one wants to do that, but you are compelled to do so if the conflict possibility potential is so great. And we use the test to test that, determine that. The test that. Okay. So, former clients. You finish your retainer with the client. Thank you very much. Good job done. Here's your final bill. Paid in full. Thank you. Lovely doing business with you. See you again next time. Who knows? Maybe. So, what does the rule about conflict say? You can't represent a client in one matter and act against them in the same or related matter. What do those words mean? Contextual, it depends. You may act against a former client in a fresh and independent matter, wholly unrelated to any previous work. What do all those words mean? Who knows, right? Depends on your facts. What are we talking about? What's wholly unrelated? What's fresh and new? Is time an element of it? Is area of law an element of it? And why? Why? Because we know why. Maintain the integrity of the legal profession. Clients should not be fettered in their choice of lawyers, and lawyers should not be hampered in the advancement of their careers. So it's possible, but we know you have to be careful. with former clients. So now let's just step back one in our trilogy case, and let's go to McDonald Estate and Marks. This is 1990, so Neil was, hang on a second, I might have some textbook excerpts to look at. Well, why don't we? Okay, page 329. Let's go to page 329 since we're on the topic. 329, get ready. I'm going to ask for a reader. 329. Yeah, I need a reader, and let's see what the, well, okay, we've already seen. Okay, so on page 329, sort of the top part of the page in the middle, that's the bright line rule, what I excerpted it for you. You saw it. So that's the bright line rule. There's your reference to it in the text. And guess what? Our model code references it too at 3.4-1. 3.4-1. Now we can have someone read it because it's not on the board. 3.4-1. Okay, 3.4-1. Reader. Online, or I have my handy dandy paper. Okay, so Nicholas, you can read the rule and then just the first commentary.
The lawyer must not act or continue to act for a client where there is a conflict of interest set as being lawyers have an ethical duty to avoid conflicts of interest. Some cases involving conflicts of interest will fall within the scope of the Bright Line Rule as articulated by the Supreme Court of Canada. The Bright Line Rule prohibits a lawyer or law firm from representing one client whose legal interests are directly adverse to the immediate legal interests of another client, even if the matters are unrelated unless the client's consent. However, the Bright Line Rule cannot be used to support tactical abuses and will not apply in exceptional cases where it is unreasonable for the client to expect that the lawyer or law firm will not act against it in unrelated matters.
Okay, so what does that commentary tell us? What is that commentary getting at?
Where there's potentially competing legal interests between clients and actual legal interests or even sometimes business conflicts.
Right, because we've seen this where the drafters of the model code, they download the Supreme Court of Canada, right, decisions. They mention the Bright Line Rule, and they use some of the same language in the commentary, right? So it's important when you read your rules, read your commentaries, because you can take your rules into your exam, lucky you, because it incorporates some of those concepts, some of those notions, some of the language that we know the Supreme Court has given us. So now it's in your rule, and the rules evolve and they're amended and changed over time as case law comes down and provides us with more guidance. Okay, so we've seen that now in the court, and we've seen it now in the rule. Okay, so that was the Bright Line Rule. Neil, before we go on to the next one, what else? Okay, McDonald Estate and Martin. And the reference there is page 302. That's where the case is. That's where the full case is. So in McDonald Estate and Martin, and you know what? Like, look, this happens. Lawyers change law firms, mobility rights, and you get a new job, or you get married, you change provinces. So what happens is Martin retains law firm A in an accounting action, whatever, and the other side has law firm B. Law firm A, law firm B. So far, so good. No problem, right? You're in litigation, you're adverse. K, a young lawyer, works at law firm A. K is a young lawyer working on at the firm, acting for one time, and was privy to confidential information. No problem, right? An associate helping a senior lawyer, you look at the documents, you look at the information, you meet the client. But what did I do? Where was that? What was the slide number?
15.
Huh?
15.
Yeah, good. So she's working there, no problem. Then she moves to law firm C. Law firm C. No problem. Mobility, young lawyers. They're moving around all the time. There's like a sweet spot of movement, right? 3, 4, 5, 6 years, whatever, off they go. So she goes to C. 2 years later, C merges with B. You see where the problem is gonna happen, right? So her firm merges with B, the firm that used to be on the other side. This is like 3-4 years later, right? Time's passed. And so she goes to law firm B, having been at A. She goes to B now because of the merger of C, whoever C was, of the merger. And she says, well, there's no involvement with the file. I don't see the file. I don't touch the file. We got a nice information wall barrier. I don't see anything. I can't access anything on the firm, on the file. And the evidence is sworn statements. We didn't talk about, I never saw anything. Nothing took place. Martin brings an application to have B, where's B? B removed because C merged and took former opposing counsel, A. And the Supreme Court unanimously supports having law firm B removed. Too bad for you. You've been in litigation for 3-4 years, you've built a ton of money, you have more coming. Too bad for you, you're off the record. You can't act because of this movement here, of this young lawyer. Poor kid, right? She like changes, she's with a new job. What does she know? Nothing's going on. Then they merge. Totally beyond her expectations. And the Supreme Court, we've seen this before. How often are they unanimous? Like they split all the time. Right? There's always a split, sometimes close, sometimes 5-2, whatever, but this is unanimous. So they feel strongly about this. Their reasons are, a disqualifying conflict of interest would occur when a reasonably informed person, whatever that means, would be satisfied the use of confidential information would occur, lawyers automatically disqualified. So there's that notion of what are the optics? What are the optics? Even though Kay, the young lawyer, and everybody else filed all these sworn statements and affidavits to say, no, never had a peek, never looked at the Martin file. It's the optics where a reasonably informed person would be satisfied. So maybe a reasonably informed person says, yeah, you never saw the file, but you went to have a cup of coffee in the kitchen and started chatting with someone about the file. Maybe you heard something. So pretty harsh application. The firm even said, no, we've taken all kinds of reasonable efforts. We put up this information wall, this barrier. She couldn't have accessed if she tried. Nope, too bad. The steps that were taken were found to be insufficient. Corey says, he agrees with the result, but you know what? He'd be even stricter. Even stricter. In the application, he says, he doesn't care about this mega firm nonsense because of the merger of B and C. I don't care about that. That doesn't justify, that does not excuse your obligations for conflicts. Too bad for you, law firm B. He's not impressed that people have to change law firms. I don't care. He says, I don't care. And he says he would impose an irrebuttable presumption. Irrebuttable presumption. A presumption, I don't care how many affidavits you file. Thank you. Too bad for you. It's irrebuttable. You can't rebut it. And the assumption is that you share confidential information, even inadvertently, over your coffee in the lunchroom. Exactly. Because the public needs to have confidence in the legal system, and the optics are bad. Optics, conflicts, doesn't have to be actual, it can be the perception. That's enough for the Supreme Court. Okay. So, what are law firms supposed to do? They read all these Supreme Court academic decisions, saying, oh man, like, how am I going to manage all this? The world's complex, people are moving around, we're a mega law firm, we have a number of issues. So, this case is a 2016 case of Chartis Insurance, and Chartis is found. You get a page reference for McDonald? Yeah, I did, right? Right, okay. So Chartis is at page 315. Okay, 315. And 315, and you can see if you just read the introduction. Okay, someone read me the introduction. This is the gist, this is the kernel of the case. Reader, 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 reader. Reader. Shimon. So just the introduction to that case on 250.
This appeal concerns the disqualification of counsel due to an alleged conflict of interest. At issue is the possibility of inadvertent disclosure of confidential information arising from the close working relationship between two lawyers after one transferred law firms to work with the other. The integrity of counsel involved is unchallenged and there is no suggestion of any actual impropriety.
Okay, so what does that little introduction tell you about how harshly the court is taking this case? Look at the last line. The last line of the introduction. Right? Right? So what does that tell you about how harsh the decision is? And this is the Ontario Court of Appeal.
It's very like they're putting too much pressure on one side and they don't want to consider much on the other.
Right? They're saying even though the integrity of counsel is unchallenged, no problem. You've got integrity, Rule 2, you're all good. No problem there. However, even though that that's not even an issue. There is no suggestion of any actual impropriety, right? There's no finding of an actual conflict. There's no finding of integrity issues with the lawyer. It's the optics. It's just how bad it looks. Because what happens is, the court says, yeah, you cannot you cannot act for the insurance company because of potential conflict of interest, despite the firm following all ethical guidelines. So the firm reads all the case law and says, holy crap, we better put in some ethical guidelines. And they write a policy and they distribute it to all the lawyers and everybody signs off that they've read it. And the court says, too bad, you can't act just because one firm previously worked on the other side of the action. Even with ethical screens, lawyers work close working relationship on unrelated matters, increase the likelihood of inadvertent disclosure of confidential information. It doesn't even say it happened. It just says it increases the likelihood, maybe not, but it's there. And even if it's inadvertent disclosure. So very high, right? Very high expectations, very high standards, the court says, even if there's no actual findings. So optics, again, are sufficient to get you into hot water. So ethical screens, so the firm says, well, give us a declaration that the ethical screens were enough. The court says, nope. The ethical screens is looking to address the actual working relationship between two lawyers that spent 50 or 60% of their time working together on unrelated matters. Doesn't matter if they're unrelated. And the Court of Appeal found the possibility of confidential information could be disclosed. The possibility supersedes the fact that the law firm followed all of the Law Society. It's LSO now, but in the day it was LSUC. And they could not rebut the presumption of inadvertent disclosure, which harkens back to that notion of the Supreme Court, right? Irrebuttable presumption. Okay, so very hard, high levels of expectations. And this is the first case since McDonald Estate v. Martin, right, which we just saw, where a Canadian court disqualified a firm in spite of ethical screens. Not enough. The Law Society can give you guidance, can give you direction of how to put in ethical screens. In this case, based on these facts, not enough. Always context specific, which is why we can never tell you it'll go this way or that. It all depends on the context. Okay, now this case is not in your materials. Where's this? Okay. This case is not, but FYI only. And this is a case where Kenora is like a town north of Newmarket. Where's Kenora? It's a small community in Ontario. So Kenora Crown attorney prosecutes a case after the defense counsel comes to the Crown's office and you can read the slide, look up the case if you want, and the decision's on a similar lines as the optics, where in a small office, people are working closely together, having coffee together. The firm was removed because what? A reasonably informed member of the public did not have confidence the confidential information could not be inadvertently disclosed to the optics. Okay. Well, this just goes on about that same case where justice should not only be done, but seen to be done. And the judge in this case also uses the test developed in McDonald Estate. So it's a more current example, right? Because this is 2017. The Kenora Crown case is 2017. Okay. How are we doing for time? Okay, so remember Mr. Strother? Mr. Strother came up second, third class or something, and Mr. Strother was the tax lawyer in BC, right? Who remembers what Mr. Strother was all about? At the time, that was, I think, loyalty was the topic of the case or something.
He reached his client informed about the change in the law.
Right, exactly. Yeah, that's a little light for me.
Yeah, I think the gist of the story is that the time there is change of the tax policy, so that kind of business is not so viable as before. So the client wind down business. Actually, the lawyers find another way to take advantage of the new change.
Right.
And then they didn't have the time. They themselves set up a business to take advantage of the policy.
Right? So he took his own personal interests to take advantage of that former client. Who would like to heard about it? Right? There's a change. Guess what? You can go back to making a lot of money making movies, right? So he provides tax advice to his client, tax shelters. They have a retainer. They have a written retainer, and the retainer states specifically that neither the lawyer or the law firm could represent other clients in relation to this scheme. So the retainer actually addresses the issue, right? And in '96, legislation changes, right? Remember, we have all that in our memories. The company winds up, and one of the former employees who got fired because the company wound up because no more tax benefits approaches Strother, says, "Oh, we could join together in a film production company because now the tax rules are beneficial." And Strother and Dee, the former employee, agreed. In 1998, Strother would receive 55% of the first $2 million. Not bad. Not a bad percentage, not a bad return. And he says, and 50% thereafter. So Strother stands, he makes some money. He's probably doing okay as a lawyer, but this is really good opportunity. He doesn't mention the potential for investment to Mark, right? Doesn't go back to the client and say, "Oh, hi, remember me a couple of years ago? You had to shut down. Well, guess what? The rules have changed." He gets the new company applies for, and they get the tax benefits. He resigns from the law firm. He says, "Man, I'm making way more money in this film business stuff, and plus I get to travel and go to exotic locations and meet famous people. This is better than practicing law. Who the heck cares about that anymore?" He resigns, and he becomes a 50% shareholder in the new company. Guess what? The old client, the former client, says, "Excuse me, I'm suing you for breach of fiduciary duty." So it goes through the courts, goes through the first level, dismissed. Court of Appeal allows the appeal. He makes him disgorge $32 million. And the law firm has to disgorge the profits as well. So the lawyer has to disgorge. You know what disgorge means, right? You can't pocket from your unethical conduct. But so does the law firm, right? Because the law firm is going to make some money through every partner or lawyer that brings in business. The law firm makes some money, the partners all share, but they have to return that money as well. So he's not going to get a Christmas card that year from them to say, "Happy holidays." The law firm has to disgorge its profits, and And everybody appeals, everybody cross appeals, because it's like, A, it's an important issue, but B, there's a lot of money involved. And what does the Supreme Court say? The Supreme Court says, yeah, you have a retainer, that's nice. Yeah, you put the firm, that's nice. But the solicitor-client relationship is overlaid with fiduciary duties. Big, giant, beautiful quilt, overlaid, covers everything. Big umbrella, covers everybody. And they may go beyond the retainer. In other words, you can write down whatever you want in your retainer. We may find that there's a bigger issue, a broader issue that overlays, that covers over all of those nicely drafted terms. And the fiduciary responsibilities include duty of loyalty, one of which is avoid conflict of interest. Any?
Yeah. So I was reading this and I wondered, when does this solicitor-client relationship end? Because since the retainer had expired, he was no longer his client. So
Yeah. Well, that's a good point, right? Because you figure, I'm done and dusted. But the Supreme Court County says, too bad for you. The Supreme Court says a former client is still a client. Your duties and conflict in respect of that former client still exist, subject to the bright line rule, which means you can't act against them in a, whatever the words were, right? Related matter or a fresh matter, like you got that test in RBA. So they say yes, but they allow for ongoing fiduciary obligations, such as starting a business where you profit and not telling your profit. So sometimes okay. I mean, I know, right? You think, all done, everything's great, I can move on to my next client, my next file, but maybe not.
June, I'm looking for my...
You'll find it.
So I think, but in this case, there was a special circumstances in terms of there was some kind of open issue left there that, okay, my business is gone, but I'm still looking for some kind of help if there's a possibility.
Like the change in the tax rule.
Yes. So there's still some kind of umbrella of...
Because what we'll see soon is the Supreme Court says, you know what? Monarch, the former client, might have been interested to hear.
Yeah.
They might have been interested to hear. Hang on, the tax rules changed. Remember all those things that made you shut down? Well, we're back with an opportunity. They might have wanted to hear that. Instead, Strother says, well, I'm not going to tell Monarch. I got a great deal going on over here. I pocket, I benefit, I'm leaving. So there's like a hook or a reason. And it's always contextual, always fact specific. But in this case, that's exactly what the Supreme Court says. They say the advice was subject to reconsideration based on these facts. The retainer talked about tax-assisted opportunities, and Strother knew, it's been 2 years, that's okay. Strother knew there was still a way to continue U.S. film studio production expenses, blah, blah. And the 98 retainer entitles the client to be told that the previous advice now had to be made. Something changed, right? The tax rules changed, or something changed. In this case, it was the tax rules. That's what the court says. The advice is subject to reconsideration. The solicitor-client relationship actually carries on. I don't care if they're former clients. Usually, you don't have a duty to alter a past opinion because of subsequent changes, but even though the retainer had come to an end, the solicitor-client relationship was based on a continuing but more limited retainer because of the tax aspect. And like if the tax rules had never changed, it might be different.
That's what I was thinking.
Right?
Exactly.
Because if there was no trigger or event.
Exactly.
And also, 2-3 years is not a lifetime. Like a file can go on 2, 3, 4, 5. It hasn't been like 15 years or anything. So, I mean, that's a component of it too, right? It's like it's happening year by year, things are changing.
But I think it's compounded by the fact that he was in the same business. That was optics, you can't get over.
It's exactly what the Supreme Court Canada said. You're in, and we'll see it. We're going to see it in a moment here. You're in a limited marketplace. Okay, so let's see it. So the Supreme Court says he Strong, has a personal undisclosed financial interest. The conflicts between clients do not impair the ability to properly represent the legal interests of both clients. Avoid a conflict. The risk did not exist here if the necessary even-handed representation had not been skewed by Strother's personal financial interest, right? A couple of $1 million, not a bad payday in '98. That's not a bad payday today. And the Supreme Court says that by acquiring a substantial and direct financial interest in one client, the new film thing, seeking to enter a very restricted marketplace, right? This is the Canadian market film industry. It's not Hollywood, which is huge. It's not Bollywood, which is huge. And what's Nollywood? What's Nollywood? That's something else. Nollywood? Yeah. Like, these are huge industries, right? Like, the Canadian industry, not quite so much. So the court says this is a restricted market in which Monarch previously had a major presence, right? Big fish, small pond. So all of these factual, contextual elements take the Supreme Court of Canada to, if this was Bollywood, where they're making billions of movies and billions of dollars and this one little speck of business, maybe not. Could be different. They don't say that, I say that. He put his personal financial interest into conflict with his duty to former client, and he compromised his duty to zealously represent Monarch's interest, sent it back, reduced the disgorgement, and there's a dissent. So there's a dissent with the Supreme Court, different opinions, all those judges, and dissent says, yes, the conflict of interest arises, but the starting point is the retainer. So the dissent kind of reads down the obligations, and they do put it into the four corners of the retainer. Not the majority, so too bad for you, the majority is what you're bound by. And they say there's no basis to overturn if the dissent had their way. Neither Strother's obligation to the new company nor personal interest directly conflicted with duties to Monarch. The Monarch retainer permitted Strother to take on new clients or new interests. So much more of a limited reading, a more focused reading on the dissent side. So what do you do? What do you do with the dissent? So you're in court and you've got a similar case and you know the majority's banged against you. What do you do with the dissent? Practically speaking, you've got in hand, you've got a fact situation, it's applicable, it's guiding law. What do you do with the dissent? What can you do? Okay, so you distinguish the majority if it's against you, right? Distinguish it's different, bigger market, whatever. But what can you do with the dissent if the dissent is in your favor? Yeah, you can argue it. You can say, well, let's look at the dissent decision of the Supreme Court of Canada, and let's look at what they say about the retainer. And when you apply it to our facts, my lady, when you apply it to my facts, the dissent is more persuasive. So let's try and expand the case law in that direction. You can try and use it. I mean, these dissents, like they're written, they're there, and if you can say these apply more directly to my case, you can try and use it that way. Good luck. Okay. So, but the majority is former clients in conflicts. The SEC found he did not have a concluded retainer. It continued because of Monarch's clear interest in hearing if the tax laws had changed. Yeah, Monarch would be interested in the reevaluation of tax potentials. It's implied that the earlier advice had been overtaken by events, changes in tax laws. But Strother kept Monarch in the dark. Get it? In the dark, it's a movie company. First it's dark, and then it's right. The Supreme Court can't do judges. I was thinking. Kept Monarch in the dark. And he reduces competition, right? Because don't forget, small marketplace, the former client was a big player. Well, if they're out of the picture, Strother and his new company, guess what? More opportunity, right? So another layer of conflict. He had a major financial interest in keeping Monarch on the silence, and nothing justified his artful silence. Get it? Artful.
You love this.
I love their language. Okay. Guess what? So that was 98, right? 2017, how many years later? This is not in your book. Strother's in your book. Believe me, I'll tell you where Strother is, because Strother's a part of Canada. Go to town on Strother. Strother's page 333. Yeah. Okay. So that's Strother. So in 2017, Mr. Strother now, no end of his troubles. How many years later? Whatever. 9 years later, he has found, in 2014, the decision's in 2017, he has found to be prosecuted by the Law Society of British Columbia for professional misconduct for the same issue. He should have advised Monarch of the favorable ruling and his involvement with his previous negative advice. Monarch was entitled to expect better advice, loyalty, full disclosure, headed. And Law Society expects better from its members. So you see, right, you've got the whole civil matter with the Supreme Court of Canada, and you've got the Law Society waiting in the wings a few years later, coming back at you for professional responsibility issues, right? And so this is 2017, and what happened, 2017. Okay, and so here's the decision. This is the BC. Who wants to read this? The BC Court of Appeal. So the Law Society makes their finding. There's an appeal to the BC Court of Appeal. The decision is 2018, so last year. So Strother's still living with this, right? In 2018, and the BC Court of Appeal decides against him. And let's read. Who wants to read? This is just a quick passage. Quick passage. It's not in your book. Yeah, here for me. Petra, just that highlighted section. This is the decision of the BC Court of Appeal after the Law Society in BC rules against Strother for professional misconduct.
Mr. Strother said he was merely operationalizing the test for professional misconduct and that he accepts the test as laid out in Martin and subsequent decisions. However, in my view, it is important to state with clarity the accepted test for professional misconduct. The test is that articulated by the Law Society in Martin and Law on Lawyer 12, a hearing panel will consider whether the lawyer's conduct was a marked departure from the conduct expected of lawyers. Put another way, the lawyer's conduct must display culpability of a gross or aggravated nature rather than a mere failure to exercise ordinary care. While I agree with Mr. Strother that not every breach of professional obligations constitutes professional misconduct, the operationalized definition he proposes adds a different focus.
So he is found, thank you. So he is found liable for professional misconduct. Court of Appeal upholds the Law Society's finding. So he's still dealing with this nonsense, 9 years later. So that's just an update on where Mr. Strother was last year.
It's not nonsense.
Pardon?
It's not nonsense. He put himself in that position.
He's still dealing with the fallout of his conduct, right? Okay, former clients, I think we looked at 3.4, did we not? Okay, so 3.4-10 is our model code rule, and it prohibits acting against a former client, and we've got that breakdown, right? Same matter, related matter, any matter, confidential information, but not if it's a fresh and independent matter. What does that mean? Who knows? It's contextual. And you've got that 3.4-1, and I think someone read this, right? This notion of immediate legal interest to concurrent client, even unrelated, all harkens back to the bright line test that we read in RVD. Okay, and then we'll take a break. Back together. Let's come back together. So before we go on to our second half of today, first of all, make sure you signed it. I'll leave it here. Second of all, a little reminder, a little refresher, because I've had some emails, some of the students, some of you students, have sent in questions and comments and so on and so forth. And so I'll touch on a few things right now. So, so on the 10/30/60, right, we know this breakdown. Class participation, and the only way to have class participation marks is to participate in the class. The title speaks for itself. The 30 is the assignment, and the assignment will be handed out whenever the syllabus says. I think it's handed out the second to last class. Yeah, I think it's the second to last class. I'll hand out the assignment. And I'm not going to give you the assignment early for two reasons. One, you haven't finished the course content. And two, the time pressure of turning around an assignment from the day you get it to the next class is part of the exercise. It's like the time pressure. If I gave you 6 weeks, you know, it wouldn't have any stress or pressure on you. So I'm going to do that. But I will tell you that the assignment, it's in the syllabus, the assignment is two parts, a written component, 500 words, like a page or something, not even too long, and then an in-class component. And the in-class component is like a moot. And that's why we have to have the 2 days, right? Because there are way too many of them. And you're going to be presenting in a moot format, in a moot context. And the parameters or the rubric that we're looking for in giving you marks and accessing the 30% of your grade are reference to case law, reference to the model code, the relevant stuff, how you present, how you articulate, how you argue your position, how you present, so that's the written, and then the oral in class is how you present, how compelling and convincing your arguments are, and your argument is based on your written work. So it kind of mimics what you would do in court, right? You write a factum and you file it. And they have limits too in the course, I think 30 pages or something. So if you write 60, too bad for you, they're going to stop reading at 30. And then you only have so much time. I think in the Supreme Court of Canada, I think you have 15 minutes. So you've got to say what you have to say to be efficient about it, and that's all part of it. And then your exam, which is December 13th? 13th. Lucky 13th. December 13th. And the exam was also based on case law, model code, application to a given set of facts. Right, so that test, little surprise, little exercise we did is an example where you have a scenario and you're told to do something and you apply the law and you apply the model code and you make yourself coherent and write your answer. Hope that helps. What would help me is if you haven't already done so, add your headshot to your Doodle. Some of you have, some haven't. And don't give me a picture of you on a bridge in Paris, you know, from that distance. I need your head, shoulders. So if you haven't done it, try and do that. Okay, those are a few housekeeping things. Questions? Ready? Okay. Castle's Rock. What's Castle's Rock? Who? What? It's a law firm. There's one of their medals is down in the display case. They give a medal or something. They were ordered to pay car dealers $45 million after class action found that the firm was in a conflict of interest because it represented two sides, right? Two sides of a insolvency proceeding with General Motors. This was 2009. There's a bailout, and the firm represents both sides, so they're in trouble. And in 2015, so that's 2009 is the bailout negotiation, and in 2015, the Superior Court of Justice found that the firm breached its fiduciary duty in contract with the dealers, and it was negligent in how it advised the restructuring and dismissed the counterclaims and so forth. So the point is to show how real-world example, right? Real-world example of a conflict of interest acting for two sides, and the whole firm is found liable to have engaged in a conflict and was ordered to pay $45 million. You know, which kind of hurts. You have to pay that kind of money back after you spent years negotiating this bailout. Okay, another example is a 2017 case, conflicts in respect of the sale of lands. Just an example for you of a conflict scenario, real world, very current. Yes, go ahead. Yeah.
Castellano.
Yeah.
Such a huge law firm.
Huge.
How come they couldn't see that conflict?
What
part
the
I don't
heck?
understand.
Right? What the heck? I mean, I think that the case goes to show that you can have ethical policies, and you can have ethical screens, and you can have information walls, and you can do all those things, and you can still get yourself into hot water. You can still still get yourself in trouble,
I
right?
think they went in it expressly because it was a lot of money, probably. Because how
Yes,
could you not see this?
I think that money was certainly a big driver, right? So in hindsight, we see it, but sometimes when you're in the thick of it and you're writing documents and you're making pleadings and you're arguing, it just escaped them. So I think it goes to show that even though they might have all kinds of policies and people in their firm that work to address these kinds of things, I mean, it still happens. It's a quagmire. It's a quagmire for sure. So another example, okay, 42. Okay, who is the McCain family?
It's former Senator McCain.
Oh, no, in Canadian context. Who's the
Oh.
McCain family? You're right, Ben. He's dead, right? He's dead. McCain family, anyone? Anybody eat frozen French fries? Yeah. Anyone from down east, Halifax, Nova Scotia, New Brunswick? So the McCain family, big, giant, huge, wealthy, stinking, filthy, rich family who makes their, historically made their fortune in potato farming. So when you buy frozen French fries, McCain, right? That's the family. And so what happens is another example of a conflict in a matrimonial case, family law. In 2016, McCain is the wife, Melanson is the husband, there's a divorce, and lo and behold, a lot of money is at issue. They're only married 8 months, and the applicant asks for annulment, the respondent for divorce is a $5 million payment if there's a divorce and so forth. And so all of that to say that this is the second divorce for the wife, the McCain person, right? Because they're filthy, stinking rich, they get married, divorced, all the time. And so what happens is the second ex-husband says, oh, you can't use the same lawyer from acting for the new husband because the old lawyer acted for the first husband. Right? And says you can't act for husband number 2 in this divorce because divorce number 1, you got all my personal confidential information. Court says, nope. Too bad for you. The court says in Nogales State, the Supreme Court established a 2-step test, remember? Governing the removal lawyer for breaching its confidence. And the questions are, if you read McDonald, it's applied here. Did the lawyer receive confidential information? Is there a risk of prejudice? And in the McCain case, the court says there must be clear, cogent evidence, not just allegations or assertions, to show that the previous retainer is related to the current retainer, and they must be reviewed carefully. There has to be a sufficient relationship. By virtue of the solicitor-client relationship with the first husband, the lawyer got a great deal of relevant confidential information about the divorce and child custody, but the motion is dismissed. And here's why. It's like a nuance, it's a take on the conflict issue. Yes, lawyer for husband 1 is the same lawyer for husband 2. And husband 1, divorcing the wife, got a whole bunch of information. Now your husband acting for husband 2, you got all this information. But what's the difference? In a
No likelihood of conflict because it's so different.
Could be such a different, right? New time period, new husband, new kids, everything's new. But how did lawyer for husband 1 get the information from the wife? Was it confidential information? Was it something that was inadvertently disclosed? No, the court says he got it perfectly legal. You do discovery, you exchange documents, everything he got, he was entitled to. There wasn't a sufficient relationship that breached the conflict of interest rules. If the lawyer had somehow obtained confidential information in a relationship with the wife, you see the difference, right? Because relationship with the wife, confidential information. Now you're going to ask for the husband, that's a clearer conflict. So in this case, real world, filthy, stinking rich people down in Halifax, can't be removed. Lawyer for husband, ex-husband number 2 cannot be removed on the basis of conflict of interest because there's no allegation that the conflict of information given to the lawyer from husband 1 was not in the category of confidential information attributable to a solicitor-client relationship to which they have no claim of right whatsoever. Would have been different if the same lawyer acted for wife in divorce 1 and then husband in divorce 2. So it's a little bit of a nuance, right? Because everything that he received, he's entitled to. And by the way, husband 2 gets the same exchange of documents and discovery. So it's never straightforward, right? It's always contextual. It always depends on the facts. It depends on the circumstances. You apply the rules and you get a different outcome. Okay. Was that it? Yeah, okay. Multiple clients. Okay, so if you have more than one client, if you have a husband and wife, or you have partners in the business, or you have more than one client collectively for whom you act, you have to disclose any conflicting interest that may exist or likely to arise. So if you can foresee in the future, this could go sideways, and we might have a conflict, I better disclose that to both parties. If there's unresolvable disputes, you may have to withdraw as one for the other. And you must disclose pre-existing relationships. So generally speaking, disclose, get your client to have ILA, and if everybody is happy and there's all the documentation in place, you're in a better position. Never 100% guaranteed. You're in a better position to act and avoid a possible conflict of interest. Scenario. Why is representing co-accused in a criminal matter, why is that potentially fertile ground for conflict of interest? Why? Co-accused. Anyone doing criminal law? There's not many criminal lawyers here, right? Okay, think about it. Why? Yeah.
Because often the co-accused may be offered a plea deal to say something about the accused, so there's a conflict.
Yeah, so I mean, you're already stuck, right? Because maybe your best strategy is, I didn't do it, she did it. She says, I didn't do it, she did it, right? And then, but you're acting for both, so where are you? Yeah, and it could be a plea bargain situation, a strategy, confidentiality. One pleads guilty, the other one testifies. So that's a ripe area. God bless you. Multiple clients. If there are contentious issues, if problems do arise when you have a group of clients, 2 or possibly 3, I guess, it's usually better to refer them out. No one likes to give away business, but sometimes it's not worth the headache for the millions. Okay. So, what is the relationship between or among the parties? Are the business partners going to stay in business 2, 3, 4, 5 years from now? Are they going to diverge? You have to anticipate some of these potential problems. Are there continuing issues? Can you represent both parties to a divorce in an uncontested divorce, or a divorce based on settlement or agreement where all the issues are agreed upon? You sign off and off you go. Maybe you can't. But if somewhere down the road their interests diverge, you have to anticipate, well, maybe the husband's not going to like this deal very much, and then you've got the problem because you're representing both parties. So you have to be a little bit prescient. Must be disclosure. That's your main guideline. So the CBA, Canadian Bar Association, we know, is a voluntary organization. You don't have to belong, but if you do, they offer you some additional rules and guidance. So that's just FYI. And we know the model code at 3.4-20 sets out the provisions for firm disqualification. The firm can be disqualified on the basis of any number of these reasons: client consents, reasonable measures, and so on. So the model code addresses in a little bit of an itemized way when a firm can be disqualified on the basis of conflict. And we've seen this, 3.4-21, this section under conflicts. Transferring lawyer cannot disclose confidential information. That includes your staff, that includes your other partners. How do you manage a conflict? Right, database, you send an email saying, we've got a new client on board. Does anybody recognize this name? Have you acted against them? Let me know. What are the, you have a screening mechanism. Within a law firm, you might have a committee. You might set up ethical screens. It doesn't work every time. And you circulate a list of new clients to everybody to see if anyone has acted against in the past. So Wallace. So now another nuance. It's never straightforward. So now we have a case where we have CN Rail, right? Big giant company. Railway goes from Newfoundland to British Columbia. And CN was a longtime client of the McKercher Law Firm. So you have a law firm, you've got this giant client, constant work, it's great. Lots of billings, lots of income, you're doing great. One of your favorite clients. Longtime client. McKercher, the same firm, decides to represent Mr. Wallace. Now, Mr. Wallace is a representative plaintiff in a class action law firm, class action litigation, representing other farmers, right? Because the railway goes all the way across Canada, goes through a bunch of farms, farmlands, and it stops along the way, picks up grain that the farmers are growing, and moves it on to market. And so the firm represents Wallace in a class action against CN for overcharging for grain haulage. Look at the damages. That's a beat. Bill. So the law firm's going, right? Because there's like a percentage in there for them. No problem. They even go so far as to remove themselves from 4 other files. So CN, constant work. Lots of files, lots of years, lots of work, lots of stuff going on. And the McKercher Law Firm says, we're just going to step back from actions 1, 2, 3, and 4 because 1.75 billion. That's all I see over here, right? So they take these steps. And CN says, excuse me, no, we don't want you representing the class action because you represented us for years. And you know all kinds of stuff about us. Lots of confidential information. Conflict of interest, right? I mean, classic case. On appeal, the court says, no, too bad for you, CN Rail. Too bad for you, CN Rail. There's no confidential information problem. There's no conflict of interest. CN was a professional litigant. Professional litigant. It could be assumed their consent was applied to act against them. What do you think the court means when they say a professional litigant, CN? What does that mean to us? What does professional litigant, what does that suggest? What is the court saying about CN?
That they use the legal system to their benefit, and they are very sophisticated.
I agree. Gia Reynolds.
I was just going to say that they probably spend a lot of time in courts, and they're, I guess they're more than just a one-shot. They can consider repeat players who are sort of always in the legal system.
Professional litigants, right? Andrew.
I have doubt with it because this law firm is a major law firm, and the same, all the major law firms are actually I act before for CN. So if we apply this rule strictly, then there's no very competent law firm to act for class action.
Right. So,
But do you see, well, yes, I agree with Julie. I think the court said that because it's a commercial, it's a major, it's an MNC, multinational corporation. You should know that this is how the process is because you're frequenting the courts. But I also see that this decision is different from King. Where the reasoning there was that, okay, these people do not represent you, they're representing themselves. In this case, they're representing CN.
Okay, good point. So it's a more classic situation of conflict. I act for you, then I act against you, right? It's more of a classic situation. On the McCains, it's I never acted for you, but I acted for a bunch of your ex-husbands, right? So that's a distinguishing feature. But I think your points are well taken. Professional litigant, limitation on access to law firms. If you said every time, nope, then all CN has to do is hire a lawyer. from one law firm in every city, and all of a sudden, good.
Or conflict.
All conflict there, right? So there's a commercial aspect to it underlying, because CN is such a big, fat, giant company. They could hire someone in every province, and just because I hire you, guess what? Your whole law firm is conflicted, right? So that would have an effect of limiting access to justice and legal representation for everybody else if CN were to say, yep, I'll just hire the one lawyer in every province and I'm good, and I'm covered, always conflicted out, right? So it's a number of layers of concerns that the Supreme Court saw with this case, and therefore took the position of professional litigant. Too bad for you. Okay,
Yeah, I was about to ask that. Do you think the Supreme Court sees these surrounding issues and somehow says, you know what, we're not going to decide from the beginning. We're not going to decide this.
I've never sat on the Supreme Court.
They said
and
that.
they are, you're next, and they are way smarter than you and me combined. I would not be surprised. If they're thinking of a policy or a theoretical issue that can be addressed and is addressed, and then they write a decision that kind of addresses that. It's an underlying issue. It's like a commercial issue. And it's there. I think it's there. Think about, and they're thinking ahead, right? Think about the consequences. You can never have these class acts. And you got poor Mr. Wallace, 25 years, he's getting shortchanged by CN.
I wanted to respond because the court in Neal recognized this. They talked about the tactical strategy.
Right.
And they really frowned upon that. And I think this would be one of those examples of that kind of tactical. Yes, the court recognized it because they mentioned it specifically, for example, in Neal.
The reality. And so, because when they make these decisions, they have consequences for, for us as lawyers, but for the people accessing access to justice. So in Wallace, the objection was found to be groundless. There was no retainer agreement that McKercher could act against them, didn't take away the implied consent. It's not a case where public confidence would be impacted, breach of loyalty, because the optics, right? What if, so the court says public confidence would not be impacted by this because the court, I'm reading into it, but with the general public, General Joe or Josephine or whatever, person say, oh, poor CN Rail, they can't have the lawyer that they want, right? Or are they going to say, poor Mr. Wallace, grinding away for 25 years on his farm, hauling, wheat onto the CN Rail and getting less money than he's entitled to. So there's that notion of professional litigant. We're not so concerned about the optics of you being in a situation where your confidential information is conflicting out a law. No. So then, after that decision, CN sues McKercher. He says, oh, really? Okay, Supreme Court of Canada, you gave me the old heave-ho. I'm going to sue the law firm. So 2013. And CN sues McKercher, let me see, page 3. So first of all, Wallace, page 321 is the case in your textbook. And the McKercher case, CNR versus McKercher is 347. So let's go there. So now the law firm's saying, hang on a second, we're a bunch of litigators, we can litigate this. So let's read the decision of CNR versus the McKercher law firm, where they tried to have the firm taken off the record. I need a reader from page 347 at the bottom. Page 347 at the bottom. I need a reader to tell us what the court said it's the Supreme Court of Canada 2013. Yeah, starting there, it's over the page 1200. 347 at the bottom, yeah.
In these reasons, I conclude that McKercher's concurrent representation of CN and Wallace fell squarely within the scope of the Bright Line Rule. The Bright Line Rule was engaged by the facts of this case. CN and Wallace were adverse in legal interests. CN has not attempted to tactically abuse the Bright Line Rule, and it was reasonable in the circumstances for CN to expect that McCurcher would not concurrently represent a party suing it for $1.75 billion. McCurcher failed to obtain CN's consent to the concurrent representation of Wallace and consequently breached the bright line rule when it accepted the Wallace retainer.
Okay. So now we have a different perspective or different angle on the issue of conflicts, where the Supreme Court says in this relationship they didn't obtain the consent. Okay. So again, case law often drives amendments and updates to our ethical rules, and this is the Law Society's Rules of Professional Conduct, and they make reference to amendments to their Rule 3.4 just by chance, similar rule number. And they amend it because at the time the rule is written, the convocation did not take into consideration the CNR versus McCurcher case, and therefore had to amend the rule and update it. Again, you've got that fluid, evolving notion of what our legal obligations and ethics are, and the Supreme Court of Canada gives us guidance and trickles down, and it's downloaded into the rules to result in amendments. That's for you Ontario lawyers. Okay. Mr. Ballon. Mr. Ballon is in conflict with his own client. Mr. Ballon's case is at page 384. Page 384. I'm just trying to think of how much time we have left. So you can read the case in page 384, but here's what happens is Ballon has a client, Ballon is a lawyer in the Law Society of Saskatchewan. He's a lawyer in commercial transactions, and he offers, and he's a real estate lawyer, and he offers to sell his building to his client, right? So now you've got a relationship of solicitor and client, but now you're going to sell your personal, your commercial building to your client. Okay, so first of all, question, maybe, whether that's a good idea or not. He offers to purchase, he drafts the offer to purchase in 2012. He doesn't tell the client to get ILA. He should have. A term of the offer contemplates $40,000 forfeit if the deal doesn't go through. The client finds out there's some bylaw enforcement problem. The client asks the lawyer about prior knowledge. The lawyer says he knew about it, but he denied the tenant's rent was in jeopardy and therefore no obligation to disclose. The client doesn't complete the purchase, and he keeps the $40,000 as per the terms of the agreement that he wrote, that he gave to his client who didn't have ILA. So you can see the context, right? So this is what the court's considering. What's the reality? What's going on here? What's going on here? The client complains to the Law Society, right? Makes sense, like what the heck? And the Law Society of Saskatchewan found that he, the lawyer, preferred his own interest over those of his client.
I was wondering if you listed a comma there.
In the penalty?
Yes, 500
well, let's just check.
comma.
Let's just check.
Because I thought it was like really ridiculous.
Well, let's just check. Oh, here it is, page 386. No zeros are missing. What you think about the penalties that the Law Societies impose as a result of breaches of ethical rules is an entirely separate issue. Lots of negative commentary.
So I guess that guy, if we go to Superior Court.
Sure, in a civil action, sure.
But I mean, you could just breach any rule for 500. Okay, I'll pay.
There are criticisms that the Law Societies are too gentle in there, for sure. That's an ongoing commentary. Okay, and so that was 2016, 2018. What happens is the Law Society issues e-bulletins. These are not in your material. Did I give you the page for Ballon? Yeah, 384, right? Yeah. Not on your materials, FYI only. There are Law Society bulletins. They give you guidance. They often flow after cases are decided. Get this in your inbox. Makes reference to acting against a former client. So we don't need to read through those. It's there for your review if you like. And these are 2018 updates. Okay. So that's what that series of slides talks about, what the Law Society in Ontario at least did in relation to some of those issues for guidance. Okay. Representation of concurrent clients, for the most part. You can represent concurrent clients provided full disclosure. So disclosure, ILA, if the client consents. I mean, it's not a guarantee, but those are good safe precautions to take. Signed and detailed waivers after ILA. And the lawyer should have a reasonable belief that they're able to represent each client without adversely affecting the other. So how do you show that? Okay, so you say Law Society comes knocking to your door. Hello, your client has complained about this, and you say, hang on, back in 2016, I took all these steps, right? I got waivers, I made full disclosure, sent him off for ILA. And the Law Society says, good for you. Now, how did you satisfy yourself that you could reasonably believe? What can you do? What can you do today to prevent against that question 2 years from now when you have this situation of possible conflict with concurrent clients? What do you do for yourself when you know they're going to ask this of you, if and when? What can you do at the time, like in real time? You note it? Yeah, write yourself an email, write yourself a memo, have someone look at the law and report back to you, give them the question, and so forth. So you can say, oh, hang on, Law Society, look, not only did I make full disclosure, here's my email and attachment, not only did I get signed waivers, and here's the ILA certificate. Oh, and by the way, back in 2016, I looked at the law, I had my junior write it up, I read it, I sat and I thought about it, and I made a note that I'm satisfied so that you have that all lined up when and if, heaven forbid, Law Society comes back. The interest of third parties. So sometimes your conflict is as between a third party and yourself acting for a client. And the general consensus is that sometimes you act for a client, but the client is incapable due to age, mental infirmity, some other reason, illness. Lawyers must ensure they put the interests of the clients first before the interests of those paying the bills, so that the person paying the bill, parent, guardian, what have you, wants to have result X, but the obligation is to the client. Is that best for the client, notwithstanding what the person who is the third party is giving instructions for? And those are cases where your practice entails dealing with individuals that need an intermediary. And are you acting on these instructions or looking past that to the client themselves and their best interest? Even though they can't necessarily directly instruct you, you have to have consideration of that.
So the work of a lawyer includes being a guardian ad litem as well?
I don't think so. I don't think it goes that far.
Oh,
I think
okay.
it asks you to stop and consider whether the instructions by the payor are the best interest of your client, because your duty lies there, notwithstanding this. I don't think it's okay. Okay, and so the Law Society, again, in their helpful nature, sets out 8 steps. Yeah. So you can read this in detail. And again, this is not in your text, but it's an example of what the Law Society of Ontario, in this case, does. It sets out guidance for dealing with conflicts of interest. It gives you a nice list, right? Step 1, determine the client, consider the nature, determine this, determine that. 5 steps. So 8 steps. So it's kind of like a little roadmap, right? Because they're there not just as your regulator to discipline you when you go off the rails, they're there to offer guidance and helpful, and they give you they have CPD programs you can watch and so forth. They're trying to help the community as well as prosecute them. So you can read all of that in detail if you like. And we know we've seen our rule 3.4-1, read the commentaries. They put a lot of meat on the bones. You can read that, it's right there, the reference is there. And talks about the bright line rule again. Excuse me, as we said, downloading guidance and content from the Supreme Court of Canada decisions into the rules. So, what have we seen today? You must not only avoid conflict of interest, you must avoid potential conflict of interest. You must be aware of the appearance of jeopardizing the confidentiality of one client through a conflict of interest, and you should not put yourself in a situation where you might be faced with that problem. Optics, not just actual crystallized conflicts. Mergers of law firms should not involve the abandonment of conflicting files. We know that from the movement of young lawyers through different law firms. Okay, so that's conflicts for today. That's it. I'm good. I'll stay if you want to ask any questions. Keep this in mind. Email me if you like. Otherwise,